Your Lordship.
Yes.
Lordship, with the consent of other side, I beg to mention item number 18, Lordship.
Item number
18.
18.
Although it is a hearing matter, old pending case, but Lordship, I am suffering some problem in my eyes, Lordship. That's why for the
Okay.
day only.
It is, you are for the respondent?
Respond number 5 to
Five.
12.
We have 40
MS,
petitions.
huh?
We have 40 petitions.
MSP Bhattacharya, Learned Counsel, representing respondent number 12.
5 to 12.
5 to 12 submits that she is not keeping well today. Accordingly, press for an adjournment. Stop. Such prayer is not opposed by the Learned Counsel for the petitioner. Accordingly, matter stands adjourned and be listed.
Any of them?
Give a date after 3 weeks. 28th of August.
Obliged, Lordship.
This is the advantage of a lawyer. Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 7, Lordship.
Item number?
For 7, Lordship. Lordship, kindly return to matter for today, Lordship. My senior is not well.
Your senior is not well.
Yes, Lordship.
Okay. On the prayer of the learned FSM, UIS Mainan, not keeping well. Adjourn. This matter will go to next week. When give a date? Not 9th. Give it on 8th. 8th.
Much
Yes.
obliged, Lordship.
May it please your Lordship. Lordship, with the consent of the other side, I beg to mention item number today. Sorry, the 20 of today's supplementary list. Lordship,
20 of today's supplementary list.
Lordship, we have received a parawise regarding this and will be filing our affidavit by this week itself. If
Okay.
possible. Lordship may list it next week.
Learned Standing Council for the Health and Family Welfare Department submits that after receipt of, submit that they have received instruction from their client
Yes.
and will be able to file affidavit by next week.
Okay.
Accordingly, a prayer for adjournment is made. Prayer is allowed. List
Lordship may list it next week itself, no problem.
next week itself. We'll listing it thereafter, not next week. They may file response also, is not it?
Lordship,
List this matter on 16th.
much obliged.
16th is a working day? Huh? 16th.
Lordship, much obliged. Lordship.
May I please, Your Lordship? My Lord, with the consent of all the parties, I beg to mention item number 17, my Lord.
Item number?
17, my Lord.
Hearing matter.
Yes, my Lord. My Lord, I'm making a mention on behalf of Mr. S. Thakur, my Lord. He is in
Okay.
bereavement, my Lord.
It is submitted that Learned Counsel Mr. S. Thakur representing respondent number 6 is bereavement. Accordingly, prayer for adjournment is made. Prayer is not opposed by the Learned Counsel for the petitioner. Full stop. Accordingly, matter stands adjourned and be listed after 3 weeks.
I'm obliged, my Lord.
Then what about 15? Yes, Mr. What about 15?
My Lord, I'm Mr. S. Thakur representing respondent number 8 to 12, my Lord.
No, what about item
Yes,
number
my Lord.
15?
Mr. V. Raskwa will be appearing in this matter.
Okay. Yes, Mr. Das.
I am appearing, madam. Yesterday's case where the such is not filed.
Okay, yesterday we have already passed this order. Allowed. Smita has dictated. In fact, I signed it. Upload that order. Yes. Yes.
NDPS matter also, he is in custody for 3 years, 11 months as on today, Lordship.
Any scan copies have come?
10 copies already received, Lordship.
Lordship,
Yes.
my senior is another Lex, Lordship.
Scan copies there.
10 copies are
What is the allegation? Tell us.
from the track, Lordship, 537 kg was recovered. That is the allegation.
533 kgs of the council place of a truck.
Yeah, other accused person, your
Okay,
Lordship.
I have granted. I remember near Belpula or somewhere
Lordship.
inside a council. Yeah. Now,
Only my submission is that 3 years, 11
no.
months.
How many witnesses were there?
9 witnesses are there.
And how many examined?
5 witnesses were examined.
9 given, 5 witness. How many days you are there?
3 years, 11 months.
3 years, 11 months. Where is the earlier order?
No, this is first time actually.
No,
Oh.
granted,
Granted
granted.
bail, Lordship, that is subsequently I came to know that is why in the record it is there, Lordship. I have given it on the other day.
No. Can you have a copy of that order?
Lordship, that
Give a copy.
here, the Lordship. This
Where is your affidavit? Bayar Dev Burma.
Yes,
We have granted 2%.
yes, 2 persons here, Lordship, already. 2 person, no, not 2 person, Lordship, 3 person. Earlier application was. two
One is
application-
Bayar Dev Burma
Yes.
and other is,
This one.
you have submitted objection also.
3 accused persons already your Lordship granted bail. Vishal Dev Burma, page 20 of my.
Give 3 orders to me.
Lordship.
Huh?
Just,
Just
It
give
is
this
in my
order. You have
file.
file objection? It is object and purpose of the written submission on behalf of the respondent narcotic. We'll consider this. We'll pass this order later on. We do not know when. These 3 orders.
2 orders, 3 petitioners.
2 orders, 3 petitions. Okay?
Obliged.
Tell Mr. Kyle that we'll record his submission. He is here in Guwahati.
Yes, Lordship.
Okay, we'll record his submission as written in the written.
Obliged.
Dispose of দেখাবা কি নে দেখাবা হচ্ছে Yes, Ahmed, what is this?
In this case,
Ah,
it was called for, and also the in second item, my lord, item 10, there is an order
hmm.
that statement of the that it was recorded and after the city is to be submitted.
Now, what to be done today?
And my lord,
POXO is there, my lord.
Hmm.
Question of service of notice is also.
Notice is served or not?
Not, not.
this my lord.
Huh?
It also is item 2,
Item
item
2,
item 9, my lord.
AB 1170.
Yes,
Where is that? This is out of the same case.
same case, my lord. We should notice, my lord, and they also
An answered notice. Notice issued to the respondent number 2 through APP as well as registered post so and so. Where is that? Plague X and Y. Yes, some. Mr. Das, what is this? You have
Notice
sent
was
it now.
also sent through our office.
Yes,
Secretary
but
office.
nothing is there.
But we have not received any service.
You
report.
have it.
Today I contacted through my office,
Ah.
the officer in charge. So they are not finding it out. So they have advised us to not again send it.
But
So-
this copy is with you. You have sent it to the,
So
from
you-
register to the officer in charge, South Salmara, Mankasa.
Yes, on
Please do-
21st of May, perhaps we sent.
Ah, 17/5 it was issued. You have received it.
Yes, on 21st of May, we dispersed it, my lord, from our. office.
Are you
It is
having
office.
do you keep a copy?
No, my lord, again, we have to my lord, send it. My lord.
my lord,
Maybe they have
This
lost
cannot
it.
be.
now you lost last order after
This is
the
B or
reference.
AB?
AB. Yeah,
What is the
another-
affair?
Perhaps he is on interim, my lord.
one case I am in.
AB is, item number 9, he is on interim. my lord.
Just Mr. 2 cases,
Same affair.
huh?
Same affair.
How can be 2 cases registered?
2 persons filed separate petitions.
So rape is same for 2 persons. How can it be same case? You rape 2 lady. Suppose.
Well.
Can it be said that this is same case?
Oh, no, I am not that.
Or the victim is the same?
No. Victim is the same.
It is the same.
Victim is the same,
There are-
2 FIRs. Oh, that case, one affair, 2 case registered,
No, one affair, one case, 2 accused persons.
2 accused person. Okay,
Separate
let us see the affair. You
just-
say in 1 case I have got, then will mean that to single accused.
No, my lord. Item.
Don't get
item 10,
confused
my lord.
and don't confuse us. Where is the affair?
FIR is page 16, my lord. Second petition, my lord.
CD is there.
Seriously.
What is the statement of the victim? If CD is there, you see, if he is a case for bail, then we'll issue a notice. If not, we'll dismiss it. Why notice is required? What is the statement of the victim?
Man,
What-
164 statement is different. 161 statements are different.
What is her basic cause? Tell us, Mr. Das.
She could not identify anybody.
Do you have any doubt?
She could not, in 161, she says
Huh.
that when she came in the night
Huh.
to close her gate,
Hmm.
4 or 5 persons picked her up and taken to nearby a pond and
Raped her.
she was
Okay,
sexually
then?
assaulted. But in 164, she
Huh.
says that when she went from one room to another room
Hmm.
of his house,
Huh.
then she was
Okay,
raped.
what is the medical report says?
Nothing. Malak, you lost me, can-
We are getting him interim here and we're calling for the statement and because ultimately we cannot grant a bail without hearing
Malak,
the.
yeah, I understand.
That's why. Who, in which case you are not on,
In second, my lord.
don't say second.
In that case, my lord, they have received a notice, not ever, that is why your lordship granted bail.
That is why. Here she has not yet received notice.
My lord, item 9, I am not in interim, my lord.
In which case you are on interim?
Item 10.
10? No, 9 not saying.
Item 9,
Item
item 9, I
nine.
am interim. Item,
AB 1170, tell us that you are on interim.
yes.
We are better
my lord.
prepared than you in a case. It will লিখিব 1170/2022. The case diary as called for by this court is produced. Another accused person has preferred a bail petition, anticipatory bail petition, being AB 1602 of 2024, which is also tagged along with this petition. However, in the said case, service is not yet complete upon the respondent number 2. That being the position, let this matter be listed after 3 weeks and on list this matter be listed on 30th of August. Interim order pass earlier shall continue. Next week লিখিব AB 160. Though the case diary called for by this court, case diary as called for by this court is produced. After perusal of the same, this court is of the opinion that the petitioner has made out a case for grant of interim protection inasmuch as the statement of the victim is having serious material, is having in the prima facie opinion of this court, serious material contradictions, as well as the medical report also do not suggest do not support the story of the victim. However, as notice has not been served upon the respondent number 2, let this matter be adjourned and be listed on 30th of August 2024 along with AB 1170/2024. Full stop. In the interim, it is provided that APR Koriba statement requires everything. Full stop. In the meantime, the learned counsel for the petitioner take fresh steps for issuance of notice upon respondent number 2 in terms of notification number. Notification number 90 dash of March so and so through the office of the public prosecutor. First of on the next date, the learned public prosecutor shall produce.
I may be permitted to return the CD for updating.
Full stop. Status. status of sub-service, full stop. The learned public prosecutor may return the case diary to update the same in as much as to incorporate the statement of the accused persons.
Okay.
Yes,
Yes, Your Lordship. Your Lordship, as the engaged counsel is under observation, she has cardiac arrest, Lordship. So, Miss S. Roy.
Consider Roy. What happened to her?
The cardiac arrest last morning.
So kindly
Okay, what is
investigate-
this IA?
For vacating the interim order.
What was the interim?
My lord.
Where is the interim order?
Yes, 13. 14 part at 14.
It is submitted by MS
P. Hajorika.
P. Hazarika that the arguing counsel MS S. Roy had held her cardiac arrest yesterday night and she is hospitalized at present. Accordingly, a prayer for adjournment is made. Prayer is allowed. List this matter. At least after 4 weeks, nothing will happen. There is a direction for correction. Correction is stayed. If we allow
In
it, that will be done.
Is
One
not-
of your colleague is in hospital,
Fine.
is not it? That is most important.
Yes, Your Lordship.
List this matter after 4 is given it.
Date negative.
3rd of September. Interim order passed earlier in the writ petition shall continue till then. Yes, Mr. Chaudhary,
Milord,
any serious business?
Milord, it's on a very narrow compass, Milord.
Okay.
Before I take your lordships to my IA,
Ah.
I'd like just to have your lordship's kind attention to the writ petition for a moment.
Yes.
Actually, what had happened in this case, Milord?
Hmm.
The government of India came up with some scheme
Okay.
for encouraging bamboo-based industry.
Oh, that case.
Basically, we are all local entrepreneur. Milord, we were basically manufacturing bamboo
Who is
lines.
representing, you are representing whom?
Your Lordship.
Huh?
CGC, Mrs. A. Gayan.
But that will not do. You call Mr.
No, no,
Are you
I'm
authorized to argue?
The other day also, my lord,
Ah.
same thing happened.
Okay.
Yes. Now what had happened, my lord?
Huh.
Pursuant to the promise given in this scheme, we set up the industry.
Okay.
Now, amongst others, one of the benefit which was given to us is at page 26. Minimum দিব লাগে যে sorry,
Yes.
page 40, I'm sorry, page 40.
Yes.
Now, this is the benefit we avail
Hmm.
on top, 5.1.
Hmm.
The scheme allows import of capital goods for pre-production, production and post-production, including CKD, SKD thereof, as well as computer software system at 5% custom duty, subject to an export obligation equivalent to 8 times of duty saved on capital goods imported under EPCG scheme to be fulfilled over a period of 8 years reckoned from the date of issue of this license. Now, when we literally, Milord, try to understand, for importing machineries which are
5%.
required for manufacturing these bamboo lines and all, out of 100% will be only 5% custom duty. But in return, what we'll have to do, we'll have to export the goods to such an extent that it offsets the duty which
Yes.
was exempted.
Well, I will be allowed to call also Mr. S.C. Gal. He is standing in for custom, well.
Okay.
কোথায় নাথাকিলে সেইদিনাখনো নাই, আজিও নাই।
Yes.
মাতা,
Allowed to.
Well, all cases are important. How can every day this is happening, my lord? Now, my lord, what had happened? There were certain developments. When Northeast industries came up, then what the Chinese authority who are leaders in this bamboo export, they lowered their price. The result we are in fix. Now, what had happened, if your lordships will kindly come to page 47. This is the letter which my lord, Chief Commissioner Northeast, he wrote to the Government of India.
47.
Page 47. Now, he said that this export
Just a minute,
obligation
just a
should be waived. The
I will-
government must,
I'll be a little bit slow today.
my lord,
I'll be a little bit slow today.
yes.
Yes.
Please come to page 47. my lord.
Yes.
It's a communication dated 14/2/2012.
Ah.
Kindly see the subject.
Hmm.
Waiver of export obligation and duty saved amount for bamboo processing machines imported under EPCG scheme by bamboo entrepreneurs from northeastern region regarding.
That's the question. Is it will be a case of promissory estoppel?
Yes,
That there is a judgment recent by my lord Justice.
Yes.
Chief Justice. What is the judgment?
this honorable court. my
No,
lord.
no, not by
Supreme Court.
Supreme Court. Justice G.Y. Chandrachud.
Uh,
Regarding this kind of a situation where
Okay.
it says that what should be the promissory estoppel and
It all started with my lord
Ah.
MP Sugar Mill,
MP Sugar.
79,
Ah.
yes. I would like to bring to your kind notice
Hmm.
that the Federation of Bamboo Industries of Assam
Hmm.
has submitted a representation address to the Revenue Secretary, Government of India, with copy endorsed to you and to undersign requesting for granting waiver of export obligation and duty saved amount for the bamboo processing machines imported under EPCG scheme by bamboo entrepreneurs from northeastern region.
Hmm.
The Federation has pointed out that in the last 5-6 years,
Hmm.
bamboo industry has started growing in other countries such as India, Vietnam, Thailand, etc., thereby posing a threat to the China, which is the largest bamboo product manufacturer in the world. In order to arrest the growth of bamboo industries in other countries, China has started reducing the selling price of bamboo products drastically to create an entry barrier for bamboo industry in other country and maintain their monopoly in the international market. The Federation submitted that since good and efficient bamboo processing machines are not available in India, the entrepreneurs import the same under EPCG scheme. But considering the Chinese hegemony in the international market, they find it difficult to export finished products from India, and fulfillment of export obligation becomes a major difficulty for them.
That eight times.
Considering, yes,
Hmm.
considering the enormous scope of bamboo-based industries in the northeastern region, it is felt that there is a need for extending special concession to this sector so that they can compete in international market. Hence, waiver of export obligation and duty saved amount for import of bamboo processing machines under EPCG scheme sought for by the Federation merits consideration.
Okay.
Look, one government authority who is in charge of this customs of entire Northeast, he is writing to the chairman CBDT, please waive these as is being demanded. The reason being the Chinese hegemony. Now, till that they have not considered my lord. Now we have filed this IA, my lord.
Hmm.
If your lordship kindly comes to the IA.
Huh.
Now I'll refer to page 21 of the IA, where Government of India itself has come up with an amnesty scheme. So we are seeking a consideration only in the light of that, my lord, in the IA.
Page 21.
21. Ek Naya Savera, one-stop solution for tax dispute resolution, scheme valid till so and so, we lord applied. Can you see cases pending in litigation, appeal, inquiry, investigation, audit, duty up to 50 lakhs, we fall in this category.
Where do we get that?
My lord,
Cases pending, first page.
yes,
Cases pending in litigation, appeal,
appeal, inquiry, investigation, audit,
duty 50 lakhs.
Up.
Pay only 30% of the
Yes.
duty. Duty more than paid less. Pay
yes,
30%.
my lord,
Now,
we
what
fall
is-
in A.
You fall in A.
A. And immediately we applied, my lord, at page 22.
Page
22. So we want, my lord,
okay, if they pass an order, at
Yes.
least we'll know the reason.
yes. As on
That
date.
what
my-
is their ground
Yes.
of rejecting
Yes.
or whether in the
It has not been rejected.
not
No,
rejected?
now if it is done.
Oh, now in that pretext, what is their reason? Then on the next litigation, we can understand.
Certainly. At least, at least we are entitled to a mandamus.
And
my lord.
any stay in this regard?
Yes,
recovery?
there is an interim procedure.
Okay, that will continue till disposal.
Yes, till disposal.
Yes, what you say?
Getting the staff compartment. I informed the girl he is coming, he is in port number 17, my lord.
He must have some assistance. Okay, we are waiting. We'll dictate the order after some time.
And deeply applied.
Ask her to be here so that
Yeah, Mr.
I will not, so that we do not make any mistake.
Yes, yes.
In
still
fact,
there.
tentatively, this is our view.
Yes.
Apparently on record says we'll record this. So in that they should have a
We're entitled to a consideration
consideration taking note of the industrial backwardness of the
area.
northeastern area. And the object was itself to promote this kind of.
In fact, my lord, bamboo product, 60% of the country's product is available in northeast.
Northeast.
Customer দিছে, the chief commissioner himself has written. Deeply.
Lordship, I created a matching parcel for the time being, learned advocate general.
Madam, time being is a difficult proposition today.
Lord-
I am not keeping absolutely well.
Lordship, name of the container number 1 and 2, that may be a stuck off. But for remaining, there is a content.
Who are the remaining?
The remaining are, Lordship, the ADC come land acquisition officer and DC.
That is a different issue. Mr. S.P. Roy, learned counsel, learned counsel for the petitioner submit that, submits that, the respondent number 1 and 2. 1 and 2?
Yes.
And where is Mr. Borua's client? Huh?
That is two, my lord.
2. And 1 is Mr. D. Sekia's client?
Yes.
1 and 2, respondent number 2 has mistakenly been arrayed as party respondent in a contempt petition, and therefore their name may be struck off from the array of parties. Full stop. MS Disekia is here.
I'm also.
He is here, available in Guwahati.
Lordship will be available in the second half, Lordship.
He is flying.
Yes,
He's also
sir.
there, my lord.
Okay.
I'm also there, yeah, at the for, that's number 1. I'm
Uh,
also representing.
Mr. Bhuya, just wait for some time. Wait for some time. Don't jump. We are going one by one. You are always excited. Why? Sometimes we feel that since we are not giving the lawyers a scope of hearing. That's why everybody is worried that this judge will not give a hearing. Is it the case? I want to know. We want to correct our defects. Is it the case? No, just tell us my query. We want to improve ourselves.
No, it's all right, my lord. From my side, it is okay. You want a little early, it's personal.
Now tell us, we will rectify our defects. No problem on that. Ki kolo? Because that flow disturbs the flow. The learned counsel representing the respondent number 1 and 2 submits that the petitioner should be imposed impose a cost for unnecessarily arraying these high ranked officers in the contempt petition, though they are no way related in this case. Be this that as it may, as Mr. S.P. Roy has submitted that their names may be struck off, we are not considering imposition of any cost. Full stop. Accordingly, the name of respondent number 1 and 2 are struck off from the array of parties from the contempt petition C-175/2024. Accordingly, the learned counsel for the petitioner to furnish amended cost title before the registry for further amendment. Full stop. Now, what is your case? Who are you?
I'm respondent number 9.
Huh?
Onil Das, 9 man.
You want to be implemented or you have
No, he
wrong?
stuck off, because in the.
Who are you?
Because
No,
originally.
who are you? Tell us.
I am not party in the original petition.
Who are you? I am asking.
I am contractor.
Contractor. Now,
And
suppose you have done something, you have obstructed justice. Any statement that you have, it's not necessary that you should be a party in the writ petition.
That is the law.
That is not the law.
Whether I am getting any benefit from this or
Benefit of which order?
from this. Because my-
Contempt can be without making any party. Suppose we pass a direction to the health department that pay this amount to him. Now, health department takes a stand that I have done everything. This finance secretary is not doing or not complying with this order. In a given case, we can implement that finance secretary as a contemptor. Is it necessary? That is the difficulty here. All parties who are party in the writ petition are being made contemptor. Suppose I passed an order yesterday, the deputy commissioner should consider their representation and pass an order. Now, suppose deputy commissioner is not doing, a contempt petition will be filed, arraying commissioner and secretary from commissioner and secretary to all in a contempt. Is it maintainable? So your application will consider. Yes, Mr. SP Roy, you file an objection in this.
Not-
In respect of
No copy has been served to me till
Okay.
date.
I'll further.
to main case what gola main
I'll
case.
further the copy.
The present application is filed by by the respondent number
9.
respondent
Unintentional
number
crime.
9 in contempt petition with a prayer that he is nowhere involved in the process and therefore his name should be deleted from array of parties. Mr. SP Roy submits that no copy of such application has been served in as much as he would like to file and reply to such IA, full stop. Accordingly, he prays for an adjournment. The learned counsel for the petitioner submits that he will give a copy of the application today itself to Mr. SP Roy, and thereafter the the petitioner, contempt petitioner shall file objection within 2 weeks from today, and thereafter list this matter on give a date.
Lordship, one thing may note, my lord, because in the original writ petition, I was not made party. Writ petition, I was
On the
not
ground, delay party on the ground that the petitioner, the applicant was not a party respondent in the original contempt petition.
party. My lord.
21st.
Obliged.
Yes.
My lord.
Both Mr. Ardhar and P. Naik are on legs. My lordship, they'll be on their way, lordship.
In the meanwhile, let me just pause it my.
Yes.
In respect of BRS granted to the petitioner or minor. My
Give us the facts, everything has gone out of
My
mind
lord.
and head.
My lord, what happened? Lordship, my appointing authority as a LDA is the Deputy Commissioner Jorhat.
What is your post?
Now, my lord, assistant senior accountant.
Just a minute. Yes,
But she's senior assistant.
Mr. Nath, can we ask him to leave?
Yes,
That
yes, yes,
will
yes.
take some time.
Yes, yes, yes.
আপনি company করুন।
Yes.
Yes.
My lord, lordship, may kind of page number come to 15, 16.
Yes.
Since why I'm showing this, because this is an BR voluntary retirement, my lord, scheme. Under that, I was given the retirement, my lord. So the rule 56. See,
No, no, go slow, go
Yes.
slow.
Please come to-
Subject to satisfactory report of
Yes.
police regarding their character
This
and
is my
attendance, the
first
following
appointment.
person are appointed as LDA cum typist in the.
this is my first appointment.
এই যে আমি আমার সহি করার কারণে যখন ফেরিল ফোল্ডারের কাজে আমি এটা ক্লিপ নিয়ে যাবো ঠিক আছে? Yes.
This is my first appointment, my lord, by the Deputy Commissioner, LDA,
Just a minute.
6th of September, 85.
Then,
Then please come to page number 17.
Hmm.
I was promoted to the post of Junior Account Assistant
Hmm.
by the Deputy Commissioner.
Just a minute. এই একটা কাম করো। রং আছে, রং গরম পানি। Listen, ঠান্ডা হয়ে যায় না? সাইলা গরম আছে, বেশি গরম। হুম? ইয়াতে তো। Yes.
Page 17, my lord, I was promoted to the post of Junior Account Assistant, my lord. That is also by Deputy Commissioner. The purpose is to show that appointing authority is the Deputy Commissioner.
Okay.
Now, page number 19. Annexure 3.
And extra 3, just a minute. Yes.
Page number 19, Annexure 3.
Ah.
Last, my lord, line, few lines, 4 lines,
Hmm.
clause 4.
Hmm.
Binapani Datto, Junior Account Assistant, promoted to the Senior Accounts Assistant, my lord. That's what, my lord. Next page, it is also by the Deputy Commissioner. 22/6/13, dated.
Yes.
Now comes the, my lord, the real part, page number 22.
Hmm.
How it started. Page number 22. Lordship has got it, my lord.
Yes.
To the Treasury Officer, application for VRS. I have the honor to inform you that I am unable to perform continue my duty.
Where page?
Page number 22.
22.
Yes.
What is page 21?
There is a type part, my lord, I've given earlier one.
Okay, okay.
That's a hazy paper, so I gave the
Okay.
typed one.
Page 22.
Page 22. That's an application to the Treasury Officer for BRS.
Hmm.
I have the honor to inform you that I am unable to continue my duty due to my ill health, and I therefore made up my mind to go for BRS. I request you kindly to accept this and grant BRS, which I signed with my best of my knowledge and belief. The original paper is in next page, 23. Page number 23.
Yes.
Petitioner's contention is come to page number 24, my lord, annexure 5.
Huh.
This is what petitioner says, my lord, here. Forcefully, the signature has been obtained from her by the responsible in this stop, my lord. That's what she has written. Just few lines, let me read, my lord, of this paper, annexure 5. On the next,
What is your prayer?
my lord, PR is to draw.
What is that?
Lordship, my lord, page number 25, let me read. In absence of my husband, it is of utmost necessity for me to serve in the post till my children complete their higher studies and find establishment. As per my date of birth mentioned in the HLC certificate, I served till January 26. Hence, I should be given the opportunity to serve continuously till the specified date of my retirement from service. While praying not to deprive me from the fundamental rights, I pray to your good self reject the
January
application.
2016?
26, 26. I have corrected. It should be 26. Yes. A small mistake. Sorry, my lord. While praying not to deprive me of the fundamental rights, I pray to your good self
Then,
to reject.
then,
Now, my lord, kindly see the original of this, my lord. Vernacular part is page number 26 and 27 and 28. I want to show page number 28. Kindly see on the left side, received, and there's a signature 21/12/21. That's important. This is, my lord, this is one Ajit Hazarika. He received, he and me sit together in the office. In the office, there is no system of putting seal. So next day when I gave it, he received it under the sign, my lord, 1/21/12/21. So that's on record, my lord. He received it, my lord. Why I'm saying so? Because they have taken a plea, it was not received. Now please come to the next page, page number 29. February 2022. Lordship has got it, my lord.
Yes.
Let me read. This is important one. Please note the memo number on top. That's important. Last number 829. Lordship has sent that.
Hmm.
And see the date 28/2/22.
Hmm.
I'll stress on this, my lord. Now kindly see the letter addressed to the petitioner by treasury officer. What it reads here? Regarding voluntary retirement of service. With the
Where?
page number 29.
This is 829.
This is page number 29.
To Binapani Datta by the
Yes,
treasury
yes,
officer.
yes. Lordship has noted the memo number top 829.
829.
And right side is the date. This is important. Now let me read what is written here. With reference to the subject cited above, it is to inform you that the petition for voluntary retirement submitted by you on 20/12/21 has been approved by the authority. Hence, you are allowed to go on BRS on 22. Now kindly note this, my lord. Lordship has approved by the authority. No mention of the authority, which because treasury officer is not the authority who can grant, my lord, approval for BRS, my lord. It is the appointing authority. And the treasury officer is not my appointing authority. He's a lower authority than the deputy commissioner. So he doesn't mention here the authority, neither he mentioned the memo number, nor he mentioned about the date, my lord, here. Nothing. And also, in government papers, the letters, my lord, you will find copies of all the documents, my lord, sent to the higher officials, my lord. And here, Director of Treasury is in charge of all the treasuries, my lord. Copy was not sent to him also. This is what, my lord. Now, next page, my lord, once somebody completes 50 years, they can go for BRS. There's no problem about it. So now please come to page number 37 of the affidavit of the Deputy Commissioner.
Who is replacing the deputy commissioner?
My lord, this is respondent number 3. It was filed on 22/8/29. The serial number of the page will be 37. Lordship has got it, my lord? Now let me read this.
When you filed this application for VRS, first application?
2012/21.
2012/21. Okay.
I filed, made to be filed, my lord, not filed.
Anyway,
Assuming, yes. Now kindly say, this order was passed on approval. This is 9/2/22. Now on top, my lord, page 37, Lordship got it, my lord. Now kindly come to top. See the memo number. This is 9/2.
Where is that?
Page 37.
829A.
Yes, 8/29. See the date right side? 9/2/22.
But this relates to Deputy Commissioner's office. That relates to the Treasury Officer's office.
No, see the memo number. Everything same. Same. See in page number 29, in that case, Lordship may come. The impugn order who has passed the order. From the same office it came up, my lord. It's not in the Deputy Commissioner office, my lord. Now come to page number 29 of my writ petition. And Lordship, can you compare?
Okay, now what is the stand of the Deputy Commissioner?
Deputy Commissioner
Deputy
says,
Commissioner says that it was placed before me. Then I sought
It is-
opinion from the additional Deputy Commissioner. Then Deputy Commissioner recommended, then I have passed this.
that he did not file the affidavit.
Yeah.
He retired and the additional Deputy Commissioner filed the affidavit, my lord.
Okay,
That is also another
okay.
point, my lord.
Now what is
Now
the
he comes.
stand of the Treasury Officer?
Treasury officer,
Hmm.
my lord, kindly please come to page number 60. Kindly see his memo number also. This is a different one again. Page number 60. Page number 61. Filed on 28/3/23. Same document, same memo numbers, Lordship will get, my lord. Page 61. Lordship has got it, my lord.
Yes.
9/2/22, left side 829A. Memo number. Come to the bottom, my lord.
Hmm.
See the memo number now. 829A A is not here.
Okay.
Lordship has got it, my lord.
Hmm.
This document I got, my lord, by through RTI from the treasury officer. The other one retired. The new one has come. I filed an application to RTI and he gave me this document, my lord, and other documents. Now I'll show, my lord. So lordship has seen same documents contain different memo numbers and 28 to 22. If the memo number is 829A, my lord, to 829, then before on 9 to 20, around 20 days back, early, how there can be 829A? It comes before. That means how these people they know that after 20 days, there will be this much of memo number, my lord. This is something mystery, my lord. Now please come to another document, my lord. Now, lordship kindly see. Please come to page number, my lord. That one memo number I have shown just now, that I received through from the affidavit of the treasury officer. Now, please come to page number 93 of my reply. Page 93.
90?
Page 93.
Okay.
'93. And the first page is 92. That RTA application reply this is. Please come to page 92 first, annexure 4.
Just a minute.
My lord.
92.
Page number 92. This application I filed to the treasury officer, my lord, for RTI, my lord, certain copies, my lord. Now, please come to 93 now. Lordship has got it, my lord.
Yes.
In this RTA reply, I have got the approval of the deputy commissioner, my lord. Kindly see the top and the bottom memo number 829A is missing totally. It is not there. And bottom sign of the deputy commissioner.
And where is the comparable report? They have annexed of this report in the, which is the other, this order is annexed by them also.
Them in the annexure, page 37, my lord. Page
Page?
37, kindly come.
Okay, okay.
And
understood.
deputy commissioner reply,
Hmm.
affidavit.
According to this page 37, there are memo numbers in this which
Page
was given in,
37.
and page 93 are totally two different.
And page 61 also, treasury officer affidavit also, a
Hmm.
different one.
Page
Page 61,
61
yes.
and page 93.
Page 37, 61, 93. Lordship will find three different memo numbers.
35,
39, not 35. First is 37.
39,
37, my lord. First is.
37, then
Yes. Then page number 61.
61, then
Then
93.
page number 93.
And this
These
three.
three documents.
Same document.
One I received from the deputy additional DC affidavit, page 37. Once I received from the treasury officer affidavit, page 61.
And one by RTI.
RTI. So three different number. Mystery, it's my lord. How before, my lord, 20 days, how one person knows, my lord, how she knows that there will be another memo number, but officially it is impossible, my lord. Now please come to another page, my lord. My affidavit. In terms of loss of direction, I filed that affidavit, my lord. It was filed on 12/3/94 in page number 107, my lord.
Yes.
107. Lordship has got it, my lord. Now. This I made photostat copy. And when I placed this on your lordship said no filing affidavit. So I have brought this document by UN affidavit, my lord. Now.
You have received it from RTI.
Kindly see, my lord, what happened now. This is interesting. Come 107 page number bottom, my lord.
Yes.
Now, lordship knows, my lord.
Yeah.
In 28 to 22, memo number was 829.
28.
22. Impin order was
28
passed.
to,
Yes.
24, not 28.
No. 28 to 22 when the impin order was passed. My lord. That will be that annexure, my lord.
Now this is 825.
Yes.
Against serial number 825.
Yes. Page number 29 of the impin order.
Page number
29 of the impin order. Of the repetition, that's the impin order.
Just a minute.
I'll just place it, then whatever lordship passes, my lord, I'll take happily, my lord. There's no problem about it. But what I feel, my lord, there's something is there. Such a clear-cut case I have not come across in my life.
29.
Page number 29, the impin order. BRS has been granted.
28 February.
Yes.
Okay, now?
See, now see on 28 to 22. Memo number is 829. Right, my lord?
I'm not good. Okay, 820 last.
Page number 20 in the repetition, lordship has got it.
Huh.
Left side kindly see. Memo number. Joint 01 BRS 829.
Just a minute.
Page 29 annexure 6 of the repetition.
Huh, that we have seen.
Yes, now I'm showing this. Now page, kindly take page 107. Now I'm showing the thing. What happened? This is what register they said they are maintaining in the office. 107. Now kindly see. 28 to 22 memo number is 829. Now please come to page number 107, my lord. After 8 to 8. Lordship has seen the number left side. Bottom 8 to 8.
28 to 2020.
My lord, here 9 will come or 28 2 will come, my lord. What they have done here, 20 to 22, they put the number here.
No, the earlier letter is 828 dated 24 to 2022 to AZ Hipen Swenso.
Yes.
Now 28 to 2022 Treasury Officer to Binapani VRS.
Here,
Okay.
see the number 829, they have written here, no problem. 28 to 29, and the right side, my lord, there is no column for dates. Kindly see, here the date starts now. See in the right side top. See, nowhere dates lordship will find, my lord. Now from the, here the date starts from this particular date, 829, 28 to 22, 829. Now, lordship, please come to page 37. See the memo number? Page 37.
Thirty-seven is a affidavit
Yes.
of
Yes, approval. I'm showing approval granted by the DC. See the memo number 829A, dated 9 to 22. Now, where this will go, my lord? Seriatim, if we follow, my lord, serially 1, 2, 3, 4, 5, 6 will come like that.
So this is 829A, which is dated 9-2.
Exactly.
Where they are in receive it 829 dated 28-2.
Exactly. Lordship has got it, my lord. I'm trying to mean 9-2 has gone bottom and 22 has come up. How, my lord? In the official seriatim, how somebody knows after 20 days, my lord, there will be such and such number? Am I clear, my lord, or shall I explain again, my lord?
Yes, yes.
Because the 28-2 number has to come bottom, my lord. And 9-2 has to go up because 9-2 February is earlier. 28 February is later. So that number will go up, my lord.
Yes.
Now this is one part, my lord. Actually, my lord, this is what, my lord. So what the fact is concerned. On this basis, they have given me BRS and that application received by the Ajit Hazarika, my lord. Accepted, received and signed, my lord. They said they have not received it in their affidavit, but you have denied this one, my lord. Now, factually this part. Now, legally, my lord. First of all, the application which has been addressed to the treasury officer, it itself is faulty, my lord. This cannot be. Because treasury officer is not the appointing authority. No way it can be addressed to him. Maximum deputy commissioner should have it.
Therefore, he has not done. You have by mistake given it to a treasury officer. Treasury officer says, okay, fine, you have given it. I'll send to the competent authority, deputy commissioner.
Deputy commissioner.
Deputy commissioner had an inquiry through additional deputy commissioner.
And how your lordship has seen, my lord?
No,
Yes.
that is
Yes.
another aspect. We'll come
Yes.
to that. So therefore, the first contention that okay, had it been a case that you have filed treasury officer allowed you to go on VRS, then yes, of course, whether you file before an authority who is competent or not is not matter. What matters is that whether order has been passed by an authority having jurisdiction. That is your case.
Without
Isn't it?
jurisdiction.
Huh?
Without jurisdiction.
So without jurisdiction, but
Yes.
he says, no, I have not passed. I have not accessed. I don't have my jurisdiction. I have sent it to the competent authority, deputy commissioner, deputy pass. I am just postman. I have intimated you.
But
As
post-
you intimated me, I have intimated.
Postman. Now you will see, my lord. Deputy commissioner himself
That
has
will
not
be
passed the
their
order.
case. Huh?
That's what, yes. Deputy commissioner himself, he ought to have passed the order. Because it is the deputy commissioner who is appointing authority. As per the rules 56C also, it is the appointing authority can grant VRS. There is no question of
Therefore-
delegation of power. No delegation of power.
So therefore, now let us see what should be the actual procedure
Yes.
for grant of
VRS.
VRS under the rule.
other rule.
And what is the law in this regard?
My-
That's all.
My lord. Now, rule 56C of the FR, my lord.
FR,
Yes.
FR. Assam, no financial manual, no. FRSR, fundamental rules, subsidiary rules.
So should we take in the meantime?
No, no, because I'll have to note it down. I'll take my book. Yes, which provision?
56 rule, FR 56C, my lord.
FR 56
C.
C.
My lord, let me read, my lord. C.
Just a minute. Voluntary retirement,
Yes, my
is
lord.
that it?
Yes.
Just a minute. These books are also very difficult
Very
to
difficult, my lord. Exactly.
find out.
Very difficult.
There is no 56.3.
My lord, can you have a look at this, my lord?
Okay, okay.
56C.
Just a minute. Okay, FR 56C.
So she's got it.
No, no, I've got it. Okay,
My lord, any government servant
just a minute. Hmm. Okay,
any government servant may, by giving notice for not less than 3 months in writing to the appropriate authority, retire from service after he has attained the age of 50 years or has completed 20 years of service, which were earlier. Note, the term appropriate authority referred to in the above clauses means the authority which has the power.
no, chapter 9 deals with compulsory retirement.
Yes, but this one compulsory, but this
Any specific rules so far relating to voluntary retirement?
this comes,
Bec-
my lord. I have seen-
Because
I-
there are scopes for resignation, there are scopes for compulsory retirement. But where is that VRS?
If your lordship sees that Supreme Court judgment also, they rely on this, my lord. This clause.
Okay.
I'll show, my lord.
Okay.
Yeah, this court of judgment also. Just a Patnak judgment is there.
Okay.
Appeals court judgment, Sangma, Dinesh Sangma judgment is there on
No,
this. my lord.
judgments are there, but these questions come to my mind.
Yes,
This is my
absolutely right.
this is my problem.
Yes, absolutely right, my lord.
But it must deal with the VRS. It deals with the whole chapter, deals with
I think there is a, my lord.
compulsory retirement. Anything. I'm
No,
not
no,
aware.
right.
That's why.
Lordship is right. In writ petition, there's government notification is there.
Hmm.
Government notification. Like that 3 months
So
notice.
there is a so according to them, they have issued the notification under 54C for the purpose of voluntary retirement.
56C, yes.
For the
Yes.
purpose of voluntary
Yes,
retirement.
page number 30 of
No,
writ
no,
petition.
tell us, this notification relates to voluntary retirement.
Yes, yes. Voluntary retirement with weightage of 5 years service. It is there.
Okay, so they
There's
are,
no
they have treated to be this 54.
Lordship is
Okay.
very absolutely right, my lord.
Yes,
Now, the appropriate authority referred to above clauses means authority which has the power to make substantive appointments to the post of service from which the government servant is required to or wants to retire.
there is no quarrel on that.
There's no quarrel on this.
Ah.
Now, my lord.
Ah.
First, here, lordship will find it says 2 things.
Hmm.
One is it should be the appointing
So your
authority.
case is, let me shorten it.
Yes.
Your case is, even if I give an VRS, you cannot make a determination within 3 months, even if I have not notified the 3 months period.
Yes. yes,
So
that's
your
what-
jurisdiction will start after 3 months is elapsed. This is your argument?
This is the argument. Yes.
Hmm.
And number 2, it is the
Hmm.
deputy commissioner.
No, that
It
we
says
understand. That argument is already there.
Yes.
You say that the application was filed before an authority, he is not competent authority under FR 56C,
Yes.
read with the what do you call it, notification.
Notification. Page number 30.
Notification.
Yes.
This is first argument. So therefore, any action done by an authority which is having no jurisdiction is nullity in the eye of law.
In the eyes of
Second
law, yes.
argument is that there is a period of 3 months for a notice period of 3 months, that 3 months mean for a person so that he can also recall there may be change of mind. Change of mind. So therefore, 3 months period is prescribed by FRC, and therefore authority, even if assume that is having jurisdiction, or an authority who has passed with jurisdiction
My lord,
could not have passed without elapse of 3 months of time.
my lord.
So
that's true.
therefore it is bad.
On these two, my lord, there are judgments.
Give us
Eh,
this
I'm
judgment.
giving, I'm giving.
And what is your third argument?
Eh,
One is that this manipulation. Your
manipulation.
allegation is that
This
there
is
is
the- this is the-
manipulation. Apparently it shows they had an intention to voluntarily retire me. This is the intention. From the day one, I have raised my defect that this signature was poor signature. Then I raised, I do not want, I have my family, there is no cause to do this. Second, therefore, in support of that page 37, page 61, and page 93.
93.
And
yes.
so far relating to the question of law, FR 6C,
Yes.
where 2
Yes.
points, one is 3 months, one is without jurisdiction.
The intention is substantiated by the fact that on 28/2/2022,
Uh,
I was allowed to go on BRS. On the same day, made the selection and they fill up the post. There's an interim order subsequently by the court. After the interim order was passed, a post fell vacant on 31/3/23, my lord.
Hmm.
That post fell vacant. Next day, they put another person there, they fill up. And now they come say there is no post. There is another fact. In my petition, an affidavit is there, my lord.
Okay.
So from there, it looks like, my lord, they wanted
See,
my outcome.
suppose we think that whole exercise is without jurisdiction, the subsequent selection will not stop us for passing an order, and they will deal with. Suppose
Absolutely.
in case we will do that,
Yes,
we'll
yes.
take note of that. So
No,
this is-
why I'm saying so,
Hmm.
as your law is following from your lordship, my lord, the intention not to oust me and to fill up, my lord, because the same day they made the selection.
therefore, nullify the intention when you allege.
Yes, I have alleged, my lord.
You have alleged.
Yes,
So you will have to make principle of law is that you will have to make specific allegation,
yes, yes.
who and how,
Paragraph,
and the party is to be before us.
paragraph 10, my lord. Just one.
That is the settled.
Paragraph
position.
10, page 10.
No, no, what about the second part? The person who has action was executed by malice is a party before us
He's the party by name.
by name. Who is representing him?
He's representing.
Okay. See, had she filed affidavit?
No.
Okay,
I have not received my.
okay, fine.
That's right. Now, my lord, this is the factual part. Now the judgment parts, my lord.
Yes.
My just a minute, my lord.
Mr. Sharma will be in difficulties now.
I have seen that your lordship is suffering from.
Not for that, for some other reason.
My lord, I'll be short.
No, no, you argue. You have not seen the reason. You will take some
Almost
time
finished,
to,
my lord.
you will take some time to see the reason. Take your seat.
2, 3, 4, 5, 6. My lord. He has mixed up my paper. 1, 2.
Just will record your arguments.
Fine.
Then we'll go to them.
Fine.
Heard Mr. Nat, M. Nat, Learned Senior Counsel, assisted by
A. Bhattacharya.
Mr. A. Bhattacharya. By the present petition, the petitioner has assailed an order dated 28/2/2022 issued by the Treasury Officer, Jorhat, whereby the purported application of the petitioner seeking voluntary retirement on filed on 28/2/2022 was allowed. উপৰত দিবা impugn order বুলি যে ক'লো, just write down within bracket annexure 6. The further direction is further prayer is to direct the respondent authorities to act upon an application dated 21/12/2021 within bracket annexure 5, comma, according to whereby, comma, according to the petitioner, she had withdrawn, she has clarified that she initial application of VRS dated, Mr. Nath,
My lord,
dated
2012,
2012,
21.
2021 was without her consent and was a forceful act. Full stop. Forceful act. Forceful act. Accordingly, accordingly, it is the case of the petitioner that the voluntary retirement, application of voluntary retirement, comma, acting upon which the petitioner has been allowed to go on superannuation is absolutely illegal, arbitrary, mala fide, and therefore same are liable to be set aside, and the petitioner is liable to be reinstated with all benefits. Full stop. While full stop. The facts of the case in nutshell, as projected by the petitioner, is that the petitioner was appointed as a lower division assistant cum typist in the Jorhat Treasury by the respondent deputy commissioner. Full stop. Subsequently, on 20/04/1998, she was promoted to the post of junior accounts assistant and was posted at the same treasury office, and such order was also issued under the signature of the deputy commissioner Jorhat. Full stop. Full stop. While she was continuing and junior accounts assistant, comma, according to the petitioner, on 20/12/2021, the respondent number 4, private respondent,
One date, promotion date, senior account assistant, page number 19.
thereafter, the petitioner was promoted to the senior accounts officer on
Account assistant
on
on 22/6/13
22/6/2013.
IDC, deputy
Huh?
commissioner, deputy commissioner. By
22/6/2013 by the deputy commissioner. Full stop. While she was working in the aforesaid post, comma, according to the petitioner, on 20/12/2021, the private respondent number 4,
Yes, my lord.
Huh?
Yes.
private respondent number 4, along with some other staff, forced the petitioner to put her signature on an application addressed to the treasury officer, that is respondent number. No, 4 is the.
4, I think.
I want the private respondent to mention the first one. Treasury officer is private respondent.
4 is treasury officer is 5, private respondent 5.
Okay. প্ৰথমতে যিটো কলা, প্ৰথমতে যিটো 4 কলা, সেইটো 5 আৰু subsequently address to the respondent number 4. Okay. However, immediately on 21/12/2021, the petitioner submitted an application before the respondent number 4 requesting to cancel her application dated 20/12/2021, signed by her under compulsion, seeking for VRS. According to the petitioner, such communication was duly received in the office of the treasury officer. However, on 28/2/2022, the impugn order voluntarily retiring the petitioner was approved and the impugn order was issued. Full stop. Improved. Full stop. In the aforesaid backdrop, Mr. Nath, learned counsel for the petitioner, referring petitioner, contends that admittedly, the employer of the petitioner is the Deputy Commissioner, Jorhat, inasmuch as it is the Deputy Commissioner who can only consider a application for VRS inasmuch as such VRS application is to be addressed to the said Deputy Commissioner. However, the purported application for voluntary retirement, however, the application for voluntary retirement purportedly filed by the petitioner was under force and therefore it was addressed to the Treasury Officer, and the Treasury Officer himself has issued the impugn order accepting the voluntary retirement, and therefore such action on the part of the respondent number 4 is without jurisdiction in terms of FR 56C. FR 56C. Full stop. It is the further contention of Mr. Nath that under FR 56C, a period of
one thing just
Yes.
Lordship put here, in the impugn order, he has mentioned has been approved by the authority. No name of the authority, no memo number, no date, nothing.
these are
Fine.
okay.
Fine.
Authority. Who though the respondent number 4 has mentioned that he had the approval of the authority. However, such communication do not disclose name or date of name of the authority or the date on which such authority has approved such voluntary retirement. Full stop. Referring to FR 56C, Mr. Nath further contends that in terms of FR 56, a procedure has been laid down for filing and acceptance of voluntary retirement, inasmuch as a period of 3 months is mandated for from the date of publication, from the date of application to the date of acceptance, so that the person who seeks for a voluntary retirement can think over it to reconsider the case, inasmuch as the authority, inasmuch as the employer can also apply their mind to the given facts, whether to apply, whether to allow such application or not. However, in the case in hand, for the mala fide intention of the respondent authorities, more particularly of the respondent number 5, comma, the respondents had hurriedly accepted such voluntary retirement, and immediately the post was filled up by them. Therefore, in the aforesaid backdrop, it is a clear case of mala fide exercise of power by the respondent number 5. Full stop. Referring to certain documents, more particularly the documents whereby it was purportedly it was intimated to the petitioner regarding acceptance or her voluntary retirement, Mr. Nath submits that the said documents as relied on by the respondent number 4, that is the Treasury Officer, comma, in the and annexed with the affidavit, comma, the document relied on by the Deputy Commissioner annexed with his affidavit, and the RTI reply and the said document received by the petitioner on the basis of an application under RTI are absolutely different, and they are the memo numbers are different in each of the cases. Referring to his additional affidavit wherein the dispatch register or register maintaining letters issued, Mr. Nath argues that there are it clearly demonstrates that there are manipulation in such record, inasmuch as a bare reading of the relevant page of such register furnished to the petitioner under RTI application demonstrate that it is absolutely an illegal exercise, and such document was inserted subsequently to cover up the illegal action of the petitioners. Full stop. Mr. Nath, while Mr. Nath relies on the judgment of the Honorable Apex Court in the judgment of a coordinate bench in Badang Neo versus State of Assam and others versus Adams reported in 2001 1 GLT 565 to contend that, which is the paragraph?
Slightly different subject, 2, 3. My lord, paragraph, my lord, 8,
Uh,
para
con-
8,
Contends that.
para 8, my lord.
That the language of 56C is very clear that in the case in hand, the without elapse of 3 months period, the action of the respondents to issue the order of voluntary retirement, even if it is assumed that the petitioner has voluntarily filed the application, is against such rule, and therefore same is liable to be set aside. Then
Then, my lord, Dinesh Chandra Sangma on the similar line, para 13.
in this context, he also relies on the decision of the Honorable Apex Court in the case of Dinesh Chandra Sangma versus State of Assam, reported in
77 4 SCC.
1977 4 SCC 441. Okay. He also relies same issue.
Now, the next is different.
Okay, what is this?
Serial number 3, my lord, kindly come to paragraph 26.
Paragraph 26.
Yes, serial number 3, lordship has got it, flag mark.
Just a minute, I've got it.
Yes.
Page to paragraph 26.
Yes,
Okay,
is settled legal proposition.
just a minute. Referring to the judgment of Honorable Apex Court in the case of retest theory versus State of UP, reported in 2010, volume 10 SCC 677, Mr. Nath contend that the application which was filed before an incompetent authority itself is bad at its inception. Therefore, any action taken upon the said application is nullity in law, and therefore the such application and therefore the impugned order is not sustainable, being issued on the basis of an action who is nullity at the inception itself. Then,
my lord, relying on that 80 years back, my lord, I'm surprised, my lord. Privy Council judges, my lord, Nazir Ahmed, 80 years back, they could foresee what is coming after 80 years, my lord. This is the funny example.
in
of
this
case.
connection, Mr. Nath also realizes
Para 11.
the celebrated judgment of Nasir Ali versus
No, this is by
no,
Justice
this is
Mehdi.
not Nasir celebrated judgment
That is para
of-
6,
of the
serial number 5.
of the Privy Council in Nazir Ahmed versus King of Emperor PC, reported in
1936 AIR.
AIR within bracket PC 253.
Yes.
Full stop.
Para 9, my lord.
That's
Ye-
all.
Yes, para 9 middle.
Okay,
And my lord, one more. That's important, my lord, one more.
that's all.
Serial number 6. No,
Then we'll come
one
to the
more.
reply. Huh?
You know, finished 2 minutes.
Okay.
In their affidavit, my lord, the treasury officer has stated it is because of that she has given some false certificate, HL certificate, all these things, my lord. Whether there is an issue here, so that comes Gill,
Okay.
my lord, Mohinder Singh Gill, para 8.
Referring to the referring to the celebrated judgment of Mohinder Singh Gill versus
versus Chief Election Commissioner.
Chief Election Commissioner, New Delhi and others. Mr. Nath contends that by way of affidavit, the reason cannot be disclosed and substantiated. According to him, in the case in hand, they have taken certain stance regarding the petitioner's conduct and inability to perform the duty, and therefore duty, full stop. According to Mr. Nath, such stand in the affidavit amounts to such stand in the affidavit further clarifies that the action is punitive, and when an action is punitive, there should be a due process of law, and therefore on the basis of affidavit, the order impugned is liable to be set aside and quashed. That's all?
Yes, sir.
Yes, Nayak.
Lordship, I am appearing only for the Treasury Officer.
Okay.
District Commissioner will be represented by one of my colleagues, Dr.
Okay.
Rahul. I'm relying on some documents straight away, Lordship, without making any submission. Page 1, Lordship. This is the letter, I mean, the application submitted by the petitioner on 2012.
Just to write down, countering such argument, Mr. Nayak, representing the respondent number 4, advance his argument relying on certain documents relating to the issue in question.
I have filed my affidavit, Lordship.
Huh?
These documents are there also.
Okay, which are also part of the record of his affidavit. Full stop. Yes.
This is page annexure. Lordship, may come to page 15. and
Page
that's answered.
15. Okay.
Page 15. Lordship, may kindly say down below one date is there.
2021.
So our application was received in the office of the Treasury Officer.
Okay.
Now, this is a letter by the petitioner praying for release her on voluntary retirement.
Okay.
Page 2 and page 3, I'm skipping Lordship. Then Lordship may come with page 4.
Page 4.
Yes, Lordship.
Just a minute, I'll flag mark it, important documents. Page 4.
Lordship, I kindly see it is a note given to the Treasury Officer Jorhat by one Digonto Kolita. Lordship is the office assistant. A letter received from Srimati Binapani Datta, senior assistant of this office, which is placed at flag A, may kindly be seen. She applied for VRS on 20th December 2021 on the ground of her age. Her date of appointment into service is 10/9/1985. As on date, the application for VRS, she has completed her service period for 36 years, 3 months and 10 days. As per rule FR 56C, she has fulfilled both the criteria of attaining the age of 50 years or 20 years of service.
Okay.
Hence, put up for necessary consideration.
Okay.
Then Lordship, this was forwarded to the Deputy Commissioner. Lordship, may kindly sit down after just below the date, DC. It was forwarded by the Treasury Officer.
Okay.
Down below, Lordship will see it's a signature by the Deputy Commissioner.
Huh.
It was forwarded to the ADC personnel.
Okay.
Comments.
Huh.
Next page, your Lordship will see. It's a note to Deputy Commissioner. Notes on
Just a minute. Referring to the documents and relying on the office note, which is part of the present affidavit of the respondent number 4, Mr. Nayak, learned counsel, submits that there is no mala fide exercise of power and the impugned order was passed following due procedure established, and therefore, if this court satisfied that procedures were duly followed, this court may not judicially review the final decision. Full stop. Referring to the page 1 of the record, Mr. Nath submits that after receipt of the application of the petitioner seeking VRS, the office assistant put a note to the Treasury Officer Jorhat recording that the petitioner is entitled for VRS as she has completed, she is having both the criteria, that is, she has attained age of 50 years and she has also completed 20 years of service, full stop. He further contends that on 24/12/2021, such note was put before the deputy commissioner and deputy, no, okay, such note was forwarded to the deputy commissioner along with service book in original for consideration of the deputy commissioner by the treasury officer himself on 27/12/2024, is not it?
Yes, 2020.
27/12/2024. It was
21.
24/12 is the deputy commissioner, treasury officer.
24
is
is the office assistant
assistant
to the treasury
treasury
officer,
officer, then treasury officer on 27/12.
lordship.
27/12/2024. Thereafter, the deputy commissioner forwarded the said note to the additional deputy commissioner personnel for his comment.
Next page.
Thereafter, the additional deputy commissioner in its note dated 24/1/2012 22 made a comment, opined that the VRS proposal may be approved as the petitioner has fulfilled the criteria for VRS for the post as verified by DDO.
Now, this is the signature of the deputy commissioner, 9/12/2022,
Thereafter, the deputy commissioner put his signature in the office note on
approving
9/1/2022,
9/2.
9/2/2022, approving the aforesaid recommendation.
Lordship.
Now,
Lordship, this file was forwarded to the office of the deputy commissioner by the office of the treasury officer. Treasury office is an establishment of the deputy commissioner. Along with this, after its approval, Lordship, one draft was forwarded to the office of the deputy commissioner, which your Lordship will find annexed along with the letter dated 28 February 2022
where do you
at
get
page 2.
of this document?
Yes, page 2.
This bunch of document,
Yes,
page 2.
page 2.
Where?
So this is a communication by the treasury
Page 2
of this bunch, Lordship.
page 2 of this bunch, okay, page 2 of this bunch. Page 4 is, okay.
Same, page 4 is same.
Okay.
Page 2 is the folded 4.
Page 2 marked by you. Okay.
Yes, Lord.
Page 2, yes.
It's a part of the repetition, Lordship. This is the impugn communication, Lordship. 28/2/2022, communicated by the treasury officer to the petitioner, Lordship, with reference to the subject cited above. It is to inform you that the petition for voluntary retirement submitted by you on 20/12/2021 has been approved by the authority. Your Lordship has seen the approval. Hence, you are allowed to go for VRS on 28/2/2022. Lordship, may kindly see the issue note, issue number.
Where do you get it? That number JT01.
JT01 VRS BD 2021-829. Next page, your Lordship will see. Along with the communication, this approval letter of the deputy commissioner was communicated. That is why it is 829A.
Okay.
829A.
Okay.
Now-
Therefore, according to Mr. Nayak, there is no procedural impropriety in accepting the VRS application of the petitioner, inasmuch as, according to him, the allegation of the petitioner as regards forceful resignation, which has been disputed by the respondents, cannot be determined in a writ proceeding. Okay. Refuting the argument of Mr. Nath as regards manipulation in document, Mr. Nayak submits that, referring to the documents in affidavit in opposition, submits that the impugn order dated 28th of February 2022 is having a issue number of small jt dot 01/VRS/B.D/2021/829. Yes, Mr. Council. Yes, Mr. Sharma, what are these? Everybody will come without any dress with a band. Where is Bar Council? I have observing this for 2-3 days. Who is this council?
Probably he's a junior or a student, Lordship.
No, not student, he's with a band. Student, we know. Student, no problem on that. Yes, Correspondent. JT.01/VRS/B.D/2021/829 dated 28 having so and so number, full stop. As the said document also contains the order of the Deputy Commissioner dated 9/2/2022, which 9/2/2022, and therefore such order of the Deputy Commissioner dated 9/2/2022 carries the issue number JT.01/VRS/BD/2021/829-A, and therefore it cannot be said that there is any manipulation of any record.
Lordship, as I have been informed, this document has 3 copies.
Okay.
In the office of the Treasury Officer as well as in the office of the Deputy Commissioner. In the main copy, Lordship, there is no such number as 829A or anything, Lordship. And the copy that was furnished to my learned petitioner in response to his RTI application, that is why without any number, Lordship.
Okay. Refuting the contention of Mr. Nath that there are differences in the documents issued by annexed in the affidavit by the Treasury Officer, by the Deputy Commissioner, and the copy received by him through RTI. Mr. Nayak contends that in the office 3 copies were kept, and the copy given to the petitioner through RTI did not contain the said name, and therefore such mistake or non-recording will not defeat justice in view of the specific office note as produced by him.
Lordship, that is. Then Lordship, we will again come to page number 5, Lordship, after same bunch.
After
page number 5.
Page number 5.
Now, Lordship has seen the approval by the DC 9/2/2022. Then again one note was put by the Office Assistant Digonto Kolida to the Treasury Officer. As the VRS proposal in respect of Srimati Binapani Datta, Senior Administrative Assistant of Jorhat Treasury, has been approved and allowed to go for VRS on 28/2/2022, the retirement benefits may be as follows. So this is the calculation. Next page, your Lordship will see the approval again by the Deputy Commissioner. Lordship will see accordingly prepared provisional pensionary benefits, DCRG, leave encashment, GS, etc., etc. These are approved, Lordship. Order prepared at for your kind approach. This has been approved, Lordship. Provisional pension, DCRG, leave encashment, GIS, and provisional pension.
Okay. Then
Lordship will see page 7. Deputy Commissioner, as per government OM number so and so, sanction is hereby accorded to Srimati Binapani Datta, retired senior assistant, accounts assistant of Jorhat Treasury, Jorhat, for drawal of rupees 79,501 only as savings fund for under state government employees group insurance. So this has been released on 14/3. Next page, Lordship will see this is unutilized leave encashment for 300 days.
Okay.
14/3.
Hmm.
Next page, your Lordship will see provisional DCRG, first paragraph. Second paragraph, provisional pension, 14/3.
Just a minute. Okay, 14/3. Page, oh yes, page 8. Page 8.
Page 9, page 7, 8, 9. Page 7, Lordship will see group insurance. Page 8, unutilized earned leave. Page 9, first paragraph, provisional DCRG. Paragraph 2, provisional pension.
Mr. Nayak, further referring to the document submits that subsequent to such decision, after following due process of law, all the benefits that petitioner is entitled was granted and duly transferred to her account. Full stop. That's all.
Next page, Lordship, this is the calculation.
That we have said that they
Page
have,
10.
everything is paid.
No, why I'm submitting
Okay.
the slip?
Okay,
Page 10.
page 10. Yes.
Lordship may see first one is provisional DCRG, leave encashment, GIS, provisional pension of March 22 and April 22. Provisional pension May 22. So she received provisional pension till 2022.
And she filed that application on 35, 2022, May.
Lordship.
That is your case that
So
she
what I'm
awaited,
submitting, Lordship, from the date of submitting her VRS application,
she was kept silent.
so she was not even attending the office. She went to the office only after obtaining a stay order from this honorable court. She went to the office to rejoin her post. For all this period, she never attended her office.
Have you
Now-
made any statement in affidavit?
Yes, Lord.
Okay, which paragraph?
Paragraph 2, yeah, sorry.
Mr. Nayak further contends that her,
Petition.
the petitioner was paid provisional pension of March 2022, April 2022, and May 2022. And referring to the statement of the respondent number 4 at paragraph
I'm finding out.
At paragraph so and so, Mr. Nayak contends that from the date of filing variance, the petitioner had never attended office, enjoyed her pensionary benefit, and she became wise and filed the writ petition in the month of May 2022. And after getting an interim order, which was passed by this court on the petitioner went to office to join.
Now, Lord, at page 11, Lordship will see the
So
application.
please ask her to give these two things,
I'm fine.
statement, which paragraph?
If not there.
Not fine. এখন আপনাদের নাই দাদা এখন আপনাদের না না
Statement.
স্টেটমেন্ট কোড আছে এটা মোৰ বয় আছে এটা মই আছে মই জাস্ট বাঞ্চ টু পৰা দেখুৱাই আছে ডকুমেন্টছ
Statement is not there.
Yes,
পেজ 11 লৰ্ডশিপ
page 11 of this document.
yes
Okay.
but this is dated 21st of December 2021
Ah.
lordship will see the first page on 20/12/2021 this is a very small letter 3-line letter lordship
Page
first page
of page of
2012
no, page.
now I am coming to page 11
Page 11, I'm at page 11.
lordship may kindly see page 1
Page 1 we have seen.
just one day prior lordship she filed an VRS application
Ah.
only 3 lines lordship
Ah.
next day she realized lordship she is not required to go for VRS application and file this long application lordship And this is dated 21st of December 2021.
Hmm.
One receipt has been shown there
Hmm.
in the next page, Lordship, page 12. But if Lordship comes to from page
Do you
14,
make any statement that we have never received this application?
yes.
Any statement, where
Yes,
is that?
statement has been made.
Just take out that statement.
I'm also giving the receipt book also, Lordship. Paragraph 7 of the affidavit, Lordship.
Paragraph 7 লিখি থৈছে or এটা side লিখি থোৱা paragraph 7 of the affidavit denying filing of subsequent application on 21/12/2021.
Our line is application dated 21/12/2021 was never submitted in the office of the Treasury Office, Jorhat, as the same was never received in this office.
Okay,
Lordship, I have also annexed,
I
Lordship,
have seen that.
page 14.
That you have that 21 first letter is there.
First letter is
Okay.
there, second letter is not there.
And referring to paragraph 7, Mr. Nayak submits that such application dated 21/12 Swencho withdrawn. This purportedly a withdrawal letter of VRS was never received in the office in as much as the receipt register of letter though shows the letter dated 28 of first letter dated 28 of August 2021. There is no record to suggest that such application was received on 21/12.
This office register, original register is with the Government
Okay.
Council, Lordship.
The office register is also in original is also with Mr. Nayak. Yes,
Lordship will see this entire case is based on two documents. One is 2012/2021 and next one is 21/12/2021. One is definitely admitted, Lordship. Under whatever circumstances he has admitted that this document has been submitted. But these documents of 21/12/2021 is not a admitted document, Lordship. It has been denied.
so that is what I have recorded.
Lordship.
You have
So
denied.
my first submission will be whether on the basis of, if this document is admitted
Hmm.
and the authority has acted upon this document, Lordship, definitely in the absence of the second letter, she does not have any case.
So that is we have recorded that on that disputed things cannot be decided. Therefore, you have by following the procedure have duly acted and issued the order.
Yes.
That we have already recorded.
Secondly, Lordship, on VRS application, that 3 months period, Lordship,
Hmm.
it is the settled law, Lordship. I don't need to place any judgment also. That 3 months period is for the authority. If the authority do not act within that period of 3 months, Lordship, on the application filed with the incumbent, then on the expiry of the 3 months, it will not be, binding for the petitioner or the incumbent to attend the office after the expiry of the 3 months.
Regarding 56 within bracket C, as are urged by Mr. Nayak, not learned senior counsel, Mr. Nayak submits that the application of 3 months is to be considered in given facts of in its case. According to him, in the admitted application, first VRS application, no period was prescribed. And until and unless a period is prescribed or a date is given by the applicant himself that her VRS should be taken for a anterior date, the respondent authorities shall be at liberty to accept such document, and there shall not be any embargo to wait for 3 months. It is up to the employer to exercise its power until and unless the petitioner gives a date of effect of such VRS.
Lordship, on this point, Lordship, I am relying upon a judgment 1999.
In this context, Mr. Nayak relies on a decision of 1999.
4 SCC 293.
4 SCC 293.
The state of Haryana and others versus SK Singhal,
SK
SINGHAL.
Yes.
paragraph 13, Lordship,
Paragraph 13.
last 7 line, I'm slowly reading,
Yes.
Lordship. What is further needed
Huh.
is that the authority concerned must pass a positive order withholding permission to retire and must also communicate the same to the employee as stated in BJ Sellat case and in another case, Lordship, before the expiry of the notice period. Here the notice period is 3 months. Consequently, there is no requirement of an order of acceptance of the notice to be communicated to the employee, nor can it be said that non-communication of the acceptance should be treated as amounting to withholding of permission. So it is also the settled law, Lordship, if within that period of 3 months, it is not accepted, it will be considered as deemed expected. That is the law settled by the Supreme Court, Lordship. So two points, Lordship.
Yeah,
One
he's also having 2
one
points.
is
One is
BRS and
development.
another one is.
Oh, that's
Now, just 2-3 points on the conduct of the petitioner, Lordship. Why the petitioner cannot be trusted when she claims that I have submitted this application of 21 December 2021 in spite of not having any record in the receipt book. Lordship, here, Lordship, it's a different case, Lordship. Another employee was there in the Jorhat Treasury, Lordship, who worked for more than his retirement age, Lordship. He overstayed, Lordship, by showing two HSLC certificates, Lordship. Accordingly, authority decided to recover about 16 lakhs of rupees, Lordship. And that recovery was upheld by the dishonorable court, Lordship. In this case also, the petitioner, who sits just next to that employee, Lordship, immediately after that judgment, Lordship, realized that she also has some difficulty so far as her HSLC certificates, HS certificate and degree certificates are concerned. Here, Lordship, an
I
inquiry
think,
was.
Mr. Nayak, I think this should, we confine this more. If you go beyond her credentials, we cannot make a conclusion. Even if you argue, he will deny. This is, I do not think we should go to there. That is not necessary for purpose of
Just
this.
one statement that on the, so far as her, I mean, 4 certificates are concerned, one inquiry is going on against
Okay.
her. But this is my case.
Yes. Anybody to address? No. No CAV business. Yes.
Lordship, I'm adopting the submissions made on behalf of the respondent number 4.
Okay.
Same person, Lord.
The private respondent number 5, learned counsel for the private respondent number 5 adopts the arguments. The parties are hard at substantive length and they have almost concluded the argument. List this matter on no CAV.
Yes, your lordship, please.
I will dictate like
No, there is no problem.
second part here only. Let this matter be listed on 27th of August 2024. On the said date, the learned counsel may, if the learned counsel for the parties wish to add some additional argument or wish to give written note of argument, they may do so. Full stop. List accordingly. You take this, Mr. Nayak.
My lord, I express my happiness to him. There's some reason behind it. Yeah, at least this file, we don't have to read much again. That's obliged, my lord.
Hey, Mosame, keep this. Bishop, bele kitab dile hobo. Yes. Anything to be added? No.
My lord,
Hearing concluded.
my lord,
Judgment reserved.
my lord, am I audible, my lord? I have
Yes,
some.
you are audible. You want to add anything?
Yes, my lord.
Yes.
If you permit, your lordship.
Yes.
I want to explain the judgment that has been relied upon by the opposite party, my lord.
Okay.
The judgment which is reported in 2022, my lord,
Volume.
6 SPC, page 223.
Which judgment?
The judgment relied by the state, my lord,
Uh,
2022
2022
6 SCC,
6 SCC,
page 223.
page 223.
State of UP through Secretary.
Which paragraph you want to refer?
I am just trying to distinguish, my lord, which has been referred and relied by the state authority, that this judgment is not applicable in my case. There was a fire, my lord, which occurred in the premises
That
of
UP judgment, that UP judgment.
this
UP judgment, a recent judgment.
my lord, UP judgment, yes, my lord.
That fire occurred.
Fire occurred. It
Huh.
was a distillery, my lord.
Huh.
Now there is a distinction between the levy of fees on a
Owned
distillery
and
and
distillery.
warehouse, my lord.
Owned and distillery.
My lord, that distinction I want to make out here so that the clarity is there prevail, my lord, that my case is not covered by that judgment.
Okay.
Now kindly come to paragraph 3 if the judgment is available before your lordship.
Mr. Singh, let us come back at 2.
My lord,
This is 1 only.
my lord.
Yes, who is item number 4? And what about item 5? We'll close it. What? No,
One document have
still you are playing.
No, one document we have prepared, but we have said we have submit by today or tomorrow. This is
Not tomorrow, today.
is a voluminous that's right.
What is this office?
It is Jorhat Development Authority.
Surhat Development. You cannot make a voluminous record Xerox.
Here because they have said that
We are sitting on Saturday morning 10:30. Come, let him come along with his documents. Or tomorrow 10:30. He is having a bus.
So
Tomorrow 10:30 he will be personally present.
today will be tried.
No try. There is no question of any try. We have seen it. Please, have you advised him that the way he has conducted, we may make observation against him? No way out, more particularly in view of his statement in the affidavit. If he is not aware of what is the provision and if that is statement is corrected, we will suggest his employer that sent out from him from this important office. We will make his recommendation to the chief secretary.
So may I pay one
At 2.
at 2 only?
At 2. Yes, Mr. Sakalti. Item?
That PF matter which your lordship had earlier heard on. Perhaps his lordship is not feeling well. I could understand.
When judge is sitting, it's not concern of whether he's feeling well or not. He's sitting means he will have to, well, that's why he's sitting. Yes. At 2. Let them consider and while considering, take note of the commissioner's note. That's all. And the industrial development of Northeast. That's all. And how much time?
No, Lordship, that Rhino Bamboo. Lordship, in this case, what happened, they file a miscase, claiming the benefit of Sabka Resource scheme. But that scheme has already been over. And
You
Lordship,
pass an order. Because according to them, we'll say either their scheme or any way to consider their case.
yes, then that,
Maybe including that scheme or any other scheme, taking note of the given facts of this case and pass a reason order. If you say they are not entitled, at least
then
we'll give reason.
yes,
Then we'll consider then question of promissory estoppel, lease, that's all, everything will come.
that
But that is not here as on date. Okay, we'll dispose it of. And next, what is any leftover? Anything, Mr.
Item 4 is there, Lordship, that can be disposed of. The matter relating to budgetary support. There were 3 types of cases. In
This
one,
is the judgment you're relying on what?
yes, Lordship.
This is, in their case?
Yes, yes.
Okay. So item,
Item 4.
item 4.
That is different. That is Muzamil Lordship.
That is so far relating to Kamal Nayan Chaudhary's case.
No. That is with regard to item number
6.
6.
What is 6?
6 is the Lordship bail application.
Bail application. With,
In this case, Lordship, witness is going on. On last occasion, one witness, that seizure witness was examined. And Lordship, regarding.
So we said that that's why we said that you have a note. We have not made up our mind.
Lordship,
We'll consider, we'll see this judgment also, then we'll pass a note.
and this is the judgment, this is a latest judgment.
Okay.
Although Lordship, facts are little different, but paragraph 5, 6, and 7 and 8.
Okay. Okay.
Written on the top. That is to be considered.
Okay. We'll consider, but this order you can get not before Monday.
Lordship, regarding fact of the case, contravenant ceased from his position.
We have seen because it was a truck used
Yes.
and it's a concealed chamber.
Yes.
Others we have granted because they were not at the
Yes.
place of the
On
seizure.
the-
He is the driver from whom it was seized and a huge quantity under a concealed.
Yes, that is the.
That is there.
With regard to item number 4,
Mm.
this matter relating to budgetary support scheme. There are 3 types of cases. In one set of cases, the scheme was challenged. That was upheld by the Supreme Court. Second of the cases, they were not entitled to, as per the department, they were not entitled to budgetary scheme. But the department issue a notification. Probably that will cover their case. Probably my learned friend, this is
Which
the order.
notification?
This is the order, Lordship.
So let them consider in terms of the notification.
And Lordship, this is the order, many requests has been disposed of by this honorable court. So
Okay.
this will cover their cases.
Okay. What is SK Agarwal? ठीक है. SCKL ठीक है. What is the demand notice dated?
Same you.
All same.
Same.
Amount?
Amount is different.
What is that amount?
2,60,108.
2,60,000.
108.
108. Okay.
Lordship.
You, Mr. Agarwal, you do one thing. You put in your dates and all in this
That will
order
do.
and give it to him.
That may
Okay.
be disposed.
Just
Much
take-
of it.
dispose of. He will write down in this, what is your difference, okay, by pencil.
Much of it.
Oh, this is item number 4, dispose of. Then 5 will after taking some time. Then 6 is done. Now we are here or other matters are over. 3 is going on. Yes, Ganguly and Mr. Chakraborty.
My lord,
But Mr. Singh is there online.
my lord,
You are in Mr. Singh, okay.
Yes.
And PK Roy and
Bhattakur is there, my lord.
Bhattakur is there. Yes, what do you propose today?
My lord, Your Lordship wanted the records. I got the record last night. And Your Lordship also indicated that if the effective date coverage can be made as my learned friend wanted from 2002.
I give the file.
Not from 2002. I wanted it from perspective.
No, there's an order passed by Your Lordship that 2000.
No, 1996.
It was
2002 initial notice period says that why it should not be covered from
No, his
2002.
case is that from the date of
Notice.
notice, that is there. But period cover is prior to the notice.
97. This is one
This-
aspect.
This is. So according to him, if this is waived from the date of,
Notice. That is what my learned friend indicated.
okay, anyway,
Your
now what
Lordship
is,
has an order to that effect also. But I tried to obtain, they said they observe because they cannot go beyond their findings. They cannot. But I find from the record, my lord, there is something which on the basis of which Your Lordship may like to give him the relief, my lord, from 2002 or 2003, even 2003. So I need to look into the whole entire record. Let me, my lord, if that can be done, because ultimately, my lord,
you want to, so sum and substance, you have received the record,
yes,
you want to go through that.
go through.
That's all?
Because ultimately, my lord, if it is 1997, you will not be able to, and what the employees will not be benefited. The purpose of the act,
According to him, where are the employees?
and then in any
Either-
case,
Even if the findings.
Anyway, so your prayer is today
that let me
to
go
say
through
that,
that.
let me go through this record. You define. This court, under its order dated, asked the learned counsel for the respondent to obtain the record for proper
got-
appreciation of this case and to obtain some instruction.
Got
Full
it.
stop. Mr. Roy, learned senior counsel submits that the record has been sent to him. However, these records are voluminous.
Hmm.
So therefore, he will require some time to go through the same. Any difficulty showing him to go through the record?
No, he
No,
can also go
what's up?
through it. He
The
can-
learned counsel for the petitioner may also go through the record
Because
so
the
that,
entire record with him, you know, it's the same record.
okay.
It is not, there is no difference.
No, that will be authenticated, that his
Yes,
record
yes.
is the original.
If he wants, I can. show it to
Okay,
him.
accordingly, matter stands adjourned and be listed on
20 August.
28th.
Let it be one day ahead, you know, 19th, because 20th.
20th is hearing day,
Hearing
19th
date.
is Monday.
28 or nahi, or otherwise on 27th.
27th.
Musubi,
27th.
27th
Okay? Yes.
on
No,
27th. Yes.
Yes.
No need to worry. No need to worry.
Why not? Well, if it's at Pathar otherwise. Then it has to. No,
Because
it will go to.
Our
exact
master-
content.
See, what happened is that my part third list, if you see, it's a huge list.
But in any case, my lord,
That is the problem.
That's an indication that.
but in
Let
any
it
case,
be remain as
my lord-
Pathar, my lord. Otherwise, my lord, if it goes to.
I
another
think, my
place,
lord,
then it
my
will-
learned friend need not worry, because the record, I have a different view, my lord, apart from what, he may get the relief, that's why, my lord.
It's not the question of getting relief, it's just to start from
That's,
one, my lord.
I have no objection. Lord.
Okay.
My lord may keep it as Pathar.
For further hearing,
Further.
further hearing.
Now, Mr. Singh, everything is over? Anything left? Yes, Kolita. Item 1-3. Brahmaputra Valley Fertilizer. What is this?
Lordship, in this case, Lordship, the Article 243Q, Lordship, prescribed for the constitution of the municipality, Lordship.
Hmm.
And with a rider, Lordship.
This high level things will go ahead today. Some other day.
But Lordship, two requisitions was last occasion heard, Lordship, and one order was passed in respect of that requisition, and that requisition was sell out, Lordship.
By which?
By one of Justice K. Goswami, Lordship. But
You say this is covered by that judgment.
But only both the requisition was allowed, Lordship, but on that date, that requisition was allowed, or in this requisition, Lordship, government was directed to produce the decision, Lordship. Because what happened, Lordship, pursuant to the draft notification was into.
As
issued,
regards status of action taken pursuant to the speaking order dated 6/12/2014. Yes, what is your instruction?
Because if
Huh?
appearing in this case,
Who is appearing? N. Goswami.
last occasion, N. Goswami.
Learned government advocate 2 weeks time to obtain instruction regards status of the action taken pursuant to the said speaking order dated 6/12/2014.
If that is not there, Lordship, then requisition, I think requisition is.
Huh? Yes, what you say?
I could not go through it. I just got.
Okay,
this
Mr.
instruction.
Talukdar, learned counsel for the learned senior counsel appearing for respondent number, state respondent submits that though he has received some instruction pursuant to the order of this court dated 16/7/2024, however, he will require some time to go through
Minutes time, I can.
so as to address this court. Full stop. Accordingly, matter stands adjourned and be listed on
Next week, Lordship.
next week. Give a date. 9th of August in the order column.
Hearing, Lordship.
Hearing, you see, we are hearing it is in the, if it comes. Okay, at least this matter is finished. Anything left? That will dispose it of. Okay, in that,
Got a copy of the judgment you were referring to?
Ah.
I just got a.
but this is, you should keep it for the next round.
But I'm just handing it over in case.
This will be your next round.
Yes, yes, Lordship, I understand.
Motilal Padmavat, yes.
Only lordships, I couldn't procure it from the bar library because the machine was not working. This does not have paragraph numbers, but I still got a copy.
Okay, I'm having
Yes,
this.
yes, lordship.
Because I dealt with this promissory estoppel in a judgment in that Madrasa teachers, whether
Lordship,
they will have a right promissory estoppel or
Yes.
not. And what is promissory estoppel?
Very interesting topic, lordship.
Then these matters I read there, therefore I recall it.
The last but 3 page, the order is very clear.
So others are over. It will 10 number file or keep it in my chamber. Others list is other as over. Anything left? Yes, 15 and 16. Yes, Raskwa.
I'm at item number 15, hearing your lordship.
How much time will you take?
Lordship, just wanted to highlight one aspect. Your lordship had given a direction to the other side. I had provided a chart of there are 2 FIRs and 2 inquiry was conducted. And your lordship's order is there dated 24/1/23.
24/1/2023
year, more than 1 year, your lordship. Learned State Council is directed to obtain the status report on the aforesaid inquiries and police
Yes,
cases.
State Council.
I had submitted a chart, your lordship. I can. Very high level inquiries have also happened, but
What is the basic issue here?
basic issue is, your lordship, what has happened? There was a news which came out. This was in the year 2018, your lordship. And on 25th of March, your lordship, a protest had happened. And your lordship, during that protest, your lordship, police firing happened, excessive force. took
Okay,
place.
okay.
10 people sustained injuries and 2 persons died, your lordship. That protest was primarily because there was a news that the Dima Hasao district is going to be bifurcated and will be, your lordship, part of the greater Nagaland, your lordship. And your lordship, here in the police has submitted their affidavits. They have submitted a report of the Dima Hasao SP, your lordship, which highlights that, your lordship, that excessive force was used, your lordship.
Okay.
And we can highlight from the
Okay,
facts of the
then,
case, your lordship. So what we are seeking, your
No,
lordship.
that is one report. And other report?
The other reports, your lordship had directed, your lordship, is forced the status report of the 2 high-level inquiry and 2 police cases. They have not submitted that.
Yes.
Need some time.
Why sometime?
5-year-old.
Sometime is difficult. Grievance of the petitioner is that 2 younger brother of the petitioner.
One brother, your lordship, was injured.
One younger brother of the petitioner was killed in police firing on 25/1/2018.
Lordship, he was injured. He
Injured.
survived, but 2 other people died, your lordship.
That is what I said. Two persons
2 persons.
died and the brother of the petitioner got injured in a police firing on 25/1/2018, which took place in Dima Hasao district. According to the petitioner, a magisterial inquiry was ordered which is not only incompetent but also vitiated by procedure irregularities, and accordingly the present application is filed. During the course of the proceeding, an affidavit has been filed by the Superintendent of Police, Dima Hasao, whose report suggests use of excess force by police. Full stop. It is also discernible that another inquiry was conducted, another high-level inquiry is conducted. In the aforesaid backdrop, this court directed the respondents to produce the assert containing facts, including 2 numbers of police cases and 2 numbers of inquiry reports. However, such order has not yet been complied with till date, though the order was passed way back on 24/1/2023. In the aforesaid background, the learned counsel, State Council, Mr. M. Setia, submits that a lunch chance may be granted to the state respondents to comply with this court's order dated 4/1/2023 and do the needful in this regard by filing an affidavit. Full stop. Prayer is allowed. Let this matter be listed on let this matter be listed on s- 2nd of September. List this matter on September. On or before said date, the affidavit be filed. Otherwise, the competent authority who needs to file this affidavit shall remain personally present before this court. A copy of this order is permitted to be, the learned counsel for Mr. Setia, learned state counsel is permitted to forward a downloaded copy of this order to the concerned officials. List accordingly.
TPO.
What is this? That's over. Yes, Mr. Singh.
Yes, my lord. I was making the distinction, my lord, in the judgment which was relied upon by the state authority.
Yes.
Kindly see the judgment. It was
McDowell judgment.
McDowell, my lord.
Yes,
McDowell.
paragraph.
First of all, paragraph 3.
Just a minute.
There was a fire incident, my lord. Fire incident where stocks which were lying in the warehouse, godown of the distillery got destroyed. Now kindly see paragraph 3, the genesis of the litigation. Paragraph 3, 3.1, my lord. The genesis.
Paragraph 3.1.
3.1. The genesis of the present litigation had been in a fire incident that took place in a godown of the distillery of the respondent company on 10/4.
Where is that page?
My lord,
I am reading SCC online.
I am reading, my lord, AIR online. So page I cannot say, my lord, but paragraph 3.1.
Here is paragraph, it starts at 2.1. Before detailing the issues. Is that it?
Subsequent paragraph, my lord.
2.1. 2.2.
The genesis of the present litigation had been.
Okay, that is paragraph 2.1. Genesis.
In a fire incident that took place in a godown of the distillery of the respondent company on 10/4/2003. I stop for a moment, my lord. So there was a fire incident in a godown of the distillery.
Yes.
Now, what is the question that was before the Honorable Supreme Court? Kindly come to paragraph 4. Perhaps it will be paragraph 3 in your printed judgment, my lord.
Next paragraph.
Next paragraph.
Having regard.
The foregoing.
In foregoing outline.
Would indicate that the focal point in this case is as to whether the appellants are entitled to levy and correspondingly the respondent is liable to pay the excise duty on the liquor destroyed in fire. As regards this focal point, 3 principal questions would require determination as noticed infra. Now, ultimately, what was the question that was before the Honorable Supreme Court? Whether destruction by fire in a distillery absolves the distillery to pay the excise duty. And if there was no negligence on the part of the employee of the distillery, whether they can get the relief.
They said, no, you cannot impose.
Yes.
Ultimate judgments, ultimate thing is that while in the fire, there is no negligence on the part of this authority. Therefore, they are not liable to pay excise.
My lord, there are 2 things to be taken note of. First, UP excise manual, and second is UP bottling of foreign liquor rules 1969.
Okay.
Now, whether first of all, whether this distillery rules or act, to what extent it is applicable in our state, number 1. Number 2, whether there was any distinction. So let us go to paragraph 40 of the judgment, my lord. It may be 39 in your printed judgment, my lord.
Just a minute. Paragraph 40.
40, my lord, in my judgment, it may be 39 also in your printed judgment, my lord.
Mr. Bhattakur, it's not having the full pages or what? 40?
40, my lord. 40.
Just a minute. After, just a minute. Okay, 40, yes. Questions for determination.
No, my lord, it starts the very same provision.
Just a minute. "35 starts with per contra learned counsel. 36 starts with while assessing the respondent had taken a precaution. Then 37 while maintaining there is no negligence.
My lord, there are certain paragraphs 39.1, 39.2. Is it there, my lord?
Yes, questions for determination. That is 41.
Questions for determination.
We have heard the learned counsel for parties at sufficient length and we have examined the materials placed on record with reference to law applicable. Questions for determination.
Okay, my lord. The relevant paragraph which I am reading, my lord, is paragraph 40, and it starts like this: the very same provision which has been interpreted.
Then
by
it
this
will
court,
be in a letter pad.
the very same provision.
Because before that, their provisions are described. Then Mr. Singh, how can you come back to Guwahati?
On 5th, my lord.
5th is not possible. I'm not here from 5th. It's an important issue.
Yes, ma'am.
So we want your...
For a moment, my lord, have you got the... I don't think it will require much hearing. I will definitely come if your lordship directs. I cannot avoid that. But may I show your lordship paragraph 40? It may
that
be...
I'm not getting that paragraph.
Okay.
That is why.
Okay, my lord.
So I'm reading all on major activity. Then I'm saying from 40 onwards. 40, we have heard the learned counsel. Just start with that. We have heard the learned counsel. Where is your paragraph? And questions for determination is quoted.
I'm trying to find out, my lord.
Just summarize your argument. Just before going to this, what will be your argument?
My argument, my lord, is that in case of distillery, the moment manufacturing is done, the Supreme Court says that there will be levy of excise duty. There cannot be any escape for the distillery. Now, I am a bonded warehouse, my lord. And what is very pertinent to note, my lord, is that here the distillery was having a go down. But at one place, the word has been used as bonded warehouse, which is out of context, my lord. If you go through the entire judgment, only once I found bonded warehouse. Actually, it was a warehouse. So distillery was concerned.
Your case is that McDowell's judgment is not applicable in
because
the given facts of the present case because that relates to a fire in a distillery and not relatable to any bonded warehouse.
My lord.
And all these judgments, Supreme Court time and again held that it is the distillery who is liable to pay after the product completion of the product, it becomes an excisable product.
My lord.
Therefore, the same principle cannot be made applicable to a bonded warehouse.
Bonded warehouse, my
This
lord.
is your
That
first
is,
one.
that is my main contention, my lord.
Okay.
And it is also, it can be read, my lord, in the Assam Excise Act.
Just a minute. We'll forget everything. Mr. Singh, while countering the argument of Mr. I. Bhattakur, submits that the judgment as relied by Mr. Bhattakur are not applicable in the given facts of the present case. Mr. Singh, learned senior counsel, contends that in the case of McDowell, within bracket Supra, it was a distillery and there was a fire incident. In the aforesaid context, the Supreme Court, while finding that there is no fault on the part of there is no negligence on the part of the distillery, and therefore the excise was not leviable.
Right.
While referring to the other judgments, Mr. Singh submits that there is no doubt then a product is excisable at the factory outlet, and therefore it is the distillery who is liable for the payment of excise and not the bonded warehouse, inasmuch as it is the McDowell judgment Supra is not relatable to any bonded warehouse.
My lord.
And
My
next.
My lord, there the Supreme Court, since the paragraphs differ, so far my printed judgment and your printed judgment are concerned, I am reading the relevant portion from para 40 of my judgment, my lord.
Just we'll do like this way. Relying on the referring to the AIR, referring to the paragraph. I will find it out. Paragraph.
It is, my lord, AIR online 2022 SC page 1441.
Okay.
AIR
Paragraph,
online paragraph 40, my lord.
Paragraph 40. Mr. Singh contends that in this context, Mr. Singh refers to paragraph 40
and 41.
40 and 41 of the judgment of McDowell as reported in AIR so-and-so. Then I will compare.
What it says, my lord, it says that the liquor that had been produced become excisable to excise duty at the end of distillation process when it was received in storage, bottling tanks, or when it was issued from the distillery. To put it differently, the taxable event was production or manufacture of liquor, for it being a duty upon the goods and not upon sale or proceeds of sale of the goods. Now, the Supreme Court is dealing with a matter which is relating to a distillery and saying basically that the moment manufacture has been completed, production has been completed, the excise duty has to be levied, no matter what happens thereafter. Now, whether there was negligence or not, that was not the context in which it could have been foregone, my lord. That is the ultimate verdict of the Honorable Supreme Court. Now, my case, my lord, is that I am a bonded warehouse.
Submits that irrespective of anything, when the final product is produced, in that moment, it becomes excisable irrespective of a point of sale, irrespective of point of sales. And therefore, it is the distillery who is liable to pay excise duty, not the bonded warehouse.
So far that judgment is concerned, my case is different. Now, may I take your lordship to section 15 of Assam Excise Act, where 15 and 16.
Assam Excise Act.
Assam Excise Act.
Yes.
My lord.
Paragraph, section?
Section 15, my lord, chapter 4.
Yes.
Now, here section 15 says, my lord, that any distillery, if it has to be constructed, a license is required. Kindly come to section 16.
16.
16, my lord.
Yes, establishment.
16D. 16 A, my lord.
Yes.
Establish a distillery in which spirit may be manufactured under a license granted under section 15. So, to establish a distillery, you need a license and approval of the government. Now kindly see, my lord, section 22.
22, method of levy of duty.
In E, in case of spirit or beer manufactured in any distillery or brewery established or licensed under section 16, as a rate charged upon the quantity produced in or issued from the distillery. Produced in or issued from. So even if it is produced and kept in the warehouse of the distillery, the moment it is issued, my lord. So basically it is the production and manufacture when the excise duty is levied upon the distillery, my lord.
Referring to section 22E of the Excise Act 1910, 1910, Mr. Singh argues that such provision is very much clear that the item becomes excisable at the distillery itself. Full stop. Is that it? Yes.
Now, my lord, kindly see Assam distillery rules.
Distillery rules. Where do you got that? Assam distillery rules. Excise manual. Assam bonded warehouse rule is there. Distillery rules.
I am relying on Assam distillery rules because I want to make a distinction, my lord, so far bonded warehouse is concerned and
But
distillery
it is not here. Yes, what you said.
is available in the old books, my lord.
Referring to clause
2
rule 2
M for Mangalore,
of distillery, Assam distillery rules 19,
which defines, my lord, as to what is 1945.
1945. Yes.
It defines as to what is a warehouse. Now, warehouse is a godown so far the state of Assam is concerned, where the distillery can store their products after manufacturing. Now, we are not concerned with any UP rules, my lord. Now, kindly come to next rule 23 and 24.
Rule 23 and 24 of
Assam distillery rules.
Distillery rules 1945.
Why I am referring, my lord? Because here also an identical provision is there which says that in case if there is any destruction due to fire, not because of negligence, then there can be some relief granted to the distillery. Since my case is totally different, but yet just to identify the as to what are the perimeter provisions in Assam rules, my lord, I am referring rule 23.
Though there are some perimeter rules to the rules of UP, which was dealt in McDowell's case, more particularly rule 22.
23 and 24.
23 and 24. Mr. Singh contends that such rule is applicable, made applicable
to a distillery.
Not to a bonded warehouse, in as much as there is separate set of rules for operation, levy of excise, etc. Under Assam bonded warehouse rules 1965, and therefore the levy can be made only on the basis of the Excise Act read with bonded warehouse rules, not with the rules meant for distilleries. Therefore, the judgment relied upon by Mr. Borthakur in McDowell's is not at all applicable in the present case.
My lord. Now, I am not reading rule 23, 24. The basic essence of the rule, my lord, is that in case if there is no negligence attributed.
That's why the negligence was dealt with.
This attributable to distillery, my lord, there may be some relief to the distillery. But my case is totally different. Now, may I take your lordship to another important aspect, which unfortunately I did not refer on 6th of March when your lordship dictated a major part of the order. Kindly look at order dated 6th of March of this honorable.
This will incorporate in that argument. Okay.
Okay. Now I am adding to one aspect, my lord. Similarly situated, two bonded warehouse. One is Paradise bonded warehouse and Ajay Datta bonded warehouse. They were given the exemption. And thereafter, so far Paradise bonded warehouse, they were never recovered, citing the reason that since there was no negligence of the bonded warehouse, in the sedimentation of the liquor, which ultimately became non-consumable to the consumer. Therefore, they are given the exemption. In my case, they have selected me. And I have referred to these two bonded warehouse in paragraph 19 and paragraph 22 of my writ petition. And there is no
Referring to paragraph 9 and paragraph
22 of my writ
22
petition.
of the of the writ petition, Mr. Borthakur, Mr. Singh contends that the petitioner has been singled out not to give such benefit inasmuch as similarly situated two bonded houses whose beers also got sedimented were granted benefit on the reason that there is no negligence on the part of the said bonded house where the beer bottles were founded with sedimentation. Similar being the case of the petitioner and admitted by the excise authorities, the petitioner cannot be levied excise.
In the excise department submitted two affidavits, my lord. The initial affidavit did not controvert. Subsequently, they submitted additional affidavit. Both the affidavits are silent as regard to my contention raised in paragraph 19 and 22. They made evasive answers. They did not touch the point which I had raised. So that
It
is
is
my
also
contention.
contention of Mr. Singh that such statement has not been denied by the respondent authorities in their affidavits, though they had filed two affidavits. In fact, in the first affidavit, they have not denied the contentions raised by the petitioner, though some evasive denial has been made in the second writ petition.
I had referred to, my lord, Rule 41 and 42 of Assam Bonded Warehouse, whereby I wanted to impress upon the Honorable Court the word that has been used is removal. So it is for the purpose of sale that when you
So
remove.
that we have already recorded because there is no
Already-
removal. Therefore, since it is not removable, it will not become excisable until and unless it is removed from the
My
bonded.
lord.
And
So-
their case is that forget about removal. Removal is for the purpose of transfer and
Sale.
point of sale, not for it will become excise only. It is since you are a bonded warehouse, this is a deferred payment. That's all.
My
So
lord.
that's all.
That's all, my lord. Rule 28 also can be taken note of Assam Bonded Warehouse, 1965.
Mr.
It is-
Singh also relies upon the Rule 28 of Assam Bonded Warehouse Rules.
It also refers to the same, my lord, that when it is removed.
To contend that until and unless excisable material are removed from the bonded warehouse, the bonded warehouse cannot be made liable for payment of excise. And in the case in hand, before removal, the beer bottles got sedimentation.
My lord.
Hearing concluded, judgment
My
reserved.
lord. Highly obliged.
Hearing concluded, judgment reserved.
I am thankful, my lord, for you having not been very in good health. I am watching you.
No, it's not question of thankfulness. It's our duty. Yes, Mr. Sharma.
In item 16, the earlier order, your 16.5 order, whereby the revenue department is directed to file affidavit if they fail to file their affidavit. In that case, the case will be decided on the materials available before. Though that was the order passed, it's my duty to show you before. But
Item 16, for any order we have passed?
16.5.
Sometime, my lord.
That is, I have placed it before your lordship, it's my duty, but lordship, the impugned order is in the last page, lordship.
Where is that item number?
16.
This is the 16.
Probably affidavit will be required from their department. Annexure 13, page 66. The land allotted to the SOS village that was directed to be converted to as a government land as because it was found to be unutilized.
Now
Why
they are
they have come to that finding that unutilized? because of that, most probably a affidavit from the revenue department will be required, Lordship.
Okay.
I am for the deputy commissioner, we have been directed to convert it, so it's the affidavit from the revenue department.
Okay, revenue plan standing counsel for a deputy department. Praise for and is granted 3 weeks time, 4 weeks time to file a deputy in opposition.
Interim may be continued.
Interim order pass earlier shall continue until further orders.
Much obliged.
Release this matter. Okay, after 4 weeks.
Lordship.
You are enjoying the land?
As well as
Enjoy.
village, that as well as
Enjoy,
village.
enjoy. We do not understand
Lordship, that is
certain
why
things. You should be guided by the principle of administration, rule of law. That we understand that is a very beautiful plot for many other purposes which may give hundreds and thousands of crores.
Lordship.
So all that's all. Yes, yes. Received?
My lord, my person from by instruction mail I'm submitting before this. My person from the GMD authority has gone to serve the copy, but they refuse to accept, my lord. This is the problem.
No, lordship. They
As per my
didn't say that
instruction.
they are coming, they are asking me where I am. So I told I am at home, so let them come, then they are coming now.
My lord, this is my instruction, my lord. They have refused.
Release this matter tomorrow.
Lordship, I'll instruct.
Release this matter tomorrow.
Yes.
It is submitted by the learned counsel for the respondent that though persons were sent to deliver the documents to the petitioner. However, the petitioner has refused to accept. On the other hand, the learned counsel for the petitioner on telephonic instruction submits that she has not refused and she is waiting at her residence to receive this copy. Full stop. The learned counsel said intimate to their respective counsels as regards the present proceeding. Full stop. If it is found that either the respondent or the petitioner is playing with the orders of this court, necessary action, a necessary order taking action against them will be passed tomorrow. Have a video photograph.
Lordship, that will be better.
You have a video photograph that she has refused. While delivering, the petitioner is permitted to have a video photograph. A respondent is permitted to have a video photograph and keep it ready. Madam, don't play.
No, Lordship.
Don't think that we are with you and therefore
No,
you will
Lordship.
become king. No.
Lordship, they are
Yes.
not giving us the
Yes.
documents.
And you are also.
They
You are also. You are also.
Documents.
You are
They are
also.
submitting the
I am
documents.
saying it because your conduct is, we are not at all happy.
And lordship,
Not at
I
all
do
happy.
Apologize for that, my lord.
We are not at all happy. Intimate them. He cannot, he don't think him that he is the some taxpayers and poor fellow under him are sitting here.
Yes, lordship.
They are submitting irrelevant documents that we have not asked for. That is the main thing.
Then you file affidavit. I'll keep it as a part tomorrow.
Because last day they have submitted, they have not leased out, but now they are saying it has
So
been.
all this file on affidavit.
Lordship.
Let us see what happens.
Lordship.
You can file an affidavit tomorrow also.
Lordship.
We have no problem on that.
If the documents are irrelevant, I'll file an affidavit, Lordship.
And
whatever
ask your
provides.
client not to take it to be an ego issue.
Obliged, lordship.
Lies, Lordship.